Welcome everybody, my name's Scott Chamberlain. I'm CEO of Chamberlain's law firm, and the presentation today we're looking at the legal aspects of your case study. Now, the presentation I've prepared, tried to simplify it as much as possible. There's an enormous number of legal issues involved in this case study, depending on how many rabbit warrens you want to go through. What I'm going to do is step through just the 4 key areas where there's legal issues, and then finish up with 2 bits. The first bit is to look at simply how lawyers work and why, when a dispute goes to lawyers, it gets out of control. And secondly, I have a little diagram on the board here because this is it's billed as a look at problem solving and defining the problem first to get the solution. And I want to step you through a model that is that I developed. It's part of a master's level unit in strategic negotiation skills that I ran through the ANU Law School for almost a decade. And it's just a nifty way of thinking about your problems, your disputes, right? So a different way of being able to dice up how you might address various situations where there's conflict and resolve them. So, excellent disclaimer, this is not legal advice, this is training. Let's have a look. From the legal perspective, in the case study, we've got 4 key problem areas. The first is the structure of the business, the way that it's been put together. The second is some of the in-house asset rules that apply for self-managed super funds. The third is the license agreement, which is one of the key pieces of intellectual property / asset of the business itself. And the final one, where there appears to be a problem, is the marriage. Business structure. The way the business has been structured is less than ideal from a risk management and governance point of view. And the first thing that you'll notice is the business is run entirely through the family trust. Completely possible to do, really not an advisable way to structure your business. There's no separation of the business from the personal side of things. Problems in either could take everything down. The same goes with the 2 businesses we have, EventMate or whatever. I don't know the case study off by heart, but EventMate plus the IT business are all assets of the family trust. And so the 2 businesses are banged together in the same entity as well, and problems in one business will flow over into the other business. So this is a classic case of all eggs in one basket. Very much it's cheap in the sense that they didn't have to pay for somebody to do 2 sets of organisations, they didn't have to pay for additional companies, etc. But it's going to be incredibly costly down the track if this situation results in a problem, particularly if the marriage splits up, particularly if one of the businesses is unable to pay its debts. Risk management, we've got both of the entities as directors. Now this is something to think about, particularly as a result of the new OH&S legislation, where there is personal liability for directors for OH&S injuries suffered by employees. As a director, you have a personal obligation to be able to know what the risks of the business are. You've actually spent some time identifying them, and you know what steps are being taken to address all of those risks. It's no longer enough to just job it out to somebody else, a CEO or someone else on the board. So both of the directors in this situation are personally liable for the OH&S risks of each of the different businesses within their family trust. Right, you see how that's a problem, particularly if I'm hands off. I'm down here trying to run an IT business and someone up is up in Queensland trying to run an event business. I want personal liability for that. And so particularly in family businesses, it is worth thinking about, well, who really should be the director? You don't all go on the board just because you're all part of the family. Maybe only one person should go on the board. Maybe it's the person with absolutely no assets to their name that goes on the board, because you don't need more than one. You also have personal liability for trading whilst insolvent and for unpaid super and PAYG tax. Okay, so being a director is not about wonderful, I'm on the board, I'm having a say. Being a director is about, oh my God, my arse is on the line. And oh my God, I could lose my house to that sinkhole over there. Now, do you really have control over it? Do you really know what's going on? And in this situation, having both of the both of the members of the family as directors is potentially not ideal. Corporate governance, again, both directors. An issue here is how are deadlocks resolved? Two directors, what happens if one agrees and the other disagrees? Now, this is the stuff at law school. It was utterly dry. One share, one vote, one seat on the board, one vote. But when it gets down to, okay, there's a deadlock, does the chairman of the board have a casting vote? Or does the chair of the meeting have a casting vote? I can tell you it's dropped down, it's knocked down, drag them out sort of stuff. As to who gets into the meeting first, who gets appointed chair, who gets to therefore run the company for the day. It's a nightmare. Finally, control. This is embedded in the case studies, this issue that Angela effectively owns the company. She is the only one who has an ordinary share in the trustee company of the trust. Now, the other shares are said to be shares that can be redeemed for no value if you leave the company. They're a special class of share. Now, if they're not voting shares, if the people holding those 500 A-class shares actually have no vote, then Angela controls the trustee of the trust. Angela controls who is on the board of the trustee. Angela controls all the family's assets. There's going to be a problem when we come down to the marriage. So, ideally, we would separate business from personal. The businesses would be owned by a separate Pty Limited company, and all shares in that Pty Limited company would be owned by a family trust. All right, so company and family trust. We separate ownership from control. We separate business from business. Each of the businesses that we've got going should be in a separate company, again wholly owned by the trust. So we separate those entities out. Why? Because they've got different risk profiles. They're different businesses, they're different assets. And if one goes down, we want to be able to just cut it loose and not have it affect the rest. Equal stake in the trustee. The trustee of the family trust should be owned equally by each spouse, i.e. each spouse should simply have one ordinary share in the trust issued for $1, in the trustee of the trust issued for $1. This business of the 500 extra shares, etc., is a nightmare for reasons we'll explain. There should be equal power of appointment. In any of the previous seminars, have you discussed trust deeds, family trust deeds, how they look? Okay, so family trust deed, how it works is that, and we have to explain, a trust is not a separate legal entity. It has a separate ABN, but it's not a separate legal entity. The only legal entity that exists is the trustee of the trust. And that can be a company, can be an individual, can be a bunch of companies, can be a bunch of individuals. In the trust deed itself, for family trusts, there is a thing called power of appointment, and somebody has the right to determine who is the trustee of the trust. Somebody has the right to remove an existing trustee and to appoint a new one. And the problem with family trusts is they're discretionary. How it works is it says the beneficiaries of this trust are any member of this group of this family, and their entitlement is completely discretionary. The trustee gets to say at the end of each financial year, you get 10%, you get 40%, you get nothing. Right? That's the problem with who controls the trust, because the trustee gets to say who in all of that discretionary group of beneficiaries gets anything at all. And so one of the crucial bits of the trust is this power of appointment. Who is it? How is it exercised? And in this particular situation, it's going to be completely relevant, particularly if there's a problem in a marriage, particularly if Angela is the person who actually controls the trustee. Finally, there should be some sort of a management agreement for the trustee. There could be some sort of agreement about how deadlocks are managed. Okay, so the trustee is just a company. If you go and register a company, what you'll get are the standard constitutional rules for a company, for a Pty Limited company. And those rules won't be sufficient to deal with this sort of situation. You need to think about how are we going to manage the trust in a way that's different to one share, one vote, chairman gets a casting vote. And in particular in this situation, the real issue is how are deadlocks to be resolved. If Angela and David can't agree on what to do, who does agree? Now that's relevant because if a company becomes deadlocked, you can wander down to the Supreme Court and ask for the Supreme Court to wind it up. So deadlocks become a gun to the head of the company. It's relevant to work out how to resolve deadlocks, because otherwise the only solution is to roll over and give the other side what they want. So the issue here is that, okay, there's enormous extra cost involved in this separation of the business. Probably something in the vicinity of between 10 and 20 grand worth of professional effort to make all that happen, which is why that happened.